Lincoln 02056199901. People say Michigan versus Carnell Really Arrow. Anytime for motion.
Appearances.
Good morning, Your Honor, and to your staff, Christina Ritter, on behalf of the people, P number 83505.
Sir.
Darnell Michael McQuarrie appearing in appropriate persona.
All right. It's my understanding, sir, you filed a motion to have Judge Bryant disqualified from the case. Judge Bryant denied your motion, and essentially your motion was thrown up to the chief judge, which is me. Is that correct, sir?
That's correct.
Okay. Argument.
Well, the argument is, sir, under Christian Code of Judicial Conduct, the judge is in violation of Canon 1 and 2 because um, I'm here falsely accused for a 21-year-old woman. And I try to speak, and she acts like Judge Judy. She just constantly cuts you off, is threatening, so far as be quiet, like, Canon 2, it says public confidence in the judiciary is eroded by irresponsible and improper conduct by judges. Judge must avoid all impropriety and appearance of impropriety. The judge must expect to be the subject of constant public scrutiny. The judge must therefore accept restrictions on conduct that might be viewed as burdensome by the ordinary citizen and should do so freely and willingly. And I come to court very respectful. I'm a 51-year-old man, and I respect the system. But I'm feeling that I'm being given, disrespect. I'm being silenced. I mean, I have a right under the free speech to petition the court for redress of grievances and things of that nature. And you look at the TV show Judge Judy. This is how she acts.
You know, there's a big difference between Judge Judy and Judge Bryant, and it's something called jurisdiction. Judge Bryant actually has it because she's a real judge. Judge Judy doesn't have jurisdiction because she is a television personality. And I wouldn't confuse the two because while Judge Judy's attitude is all for entertainment, Judge Bryant's attitude comes out only when she's dealing with people who completely disrespect her courtroom.
Totally wrong. She asked me what did I want to do with the case. I said I would like to challenge jurisdiction because I went to prison in '02 for 15 years and 8 months. They had under the rule, if I believe for misdemeanors 40 something days, for felonies is 6 months. So I request that the prosecutor prove his authority in bringing these charges so late. I have been home 6.5 years, productive in the community, no problems, and I'm trying to do right, Judge. I made huge mistakes when I was a young man, and I'm just being treated like I'm just a criminal. I'm supposed to be innocent until proven guilty, right?
There are a couple of major takeaways here. First, if you spent 15 years in prison and still don't understand that the state has jurisdiction over you, that's a serious problem. Second, it's quite bold to claim you've been a productive member of society since your release when you're currently on trial for the attempted murder of your own brother.
So I'm not trying to disrupt this court. I'm not trying to cause you guys hardships or anything, things of that nature. And my due process is being violated. That's all I want to just this case so would be left alone. But I'm a grandfather. I have children. He has retaliated against me. I know this is Detroit Police Court, and I would like an investigation as to things that's been going on by the prosecutor's office. Because Kim Worthy and her subordinates have retaliated against me. Snatch growth. At this point, I don't know if you're familiar with Bill Proctor. He's represented me in this matter and another matter so far as investigations for years of, hardships and tyranny committed against me by the fifth mayor Wayne. So this is all I want: a fair shake judge, a judge who's going to give me due process and give me what I'm entitled to according to law. And that's it.
Ms. Ritter, would you like to respond in any way?
Judge, the only response that people have is that this is a case from 2002. It's a misdemeanor assault and battery case. Judge, from my recollection of the prior hearing with Judge Bryant, I do believe, if I'm not mistaken, that it was an arraignment process. And as the court was trying to proceed with the process, I do remember Mr. McQuarrie interrupting the judge while she was trying to make the record. But people have not gotten to the point where, because Mr. Carnell was disruptive during the proceedings, people didn't get to the point where there was another pretrial date set where the people could actually see if we're able to move forward on this 2002 case.
In other words, he couldn't stay quiet long enough for Judge Bryant to even finish the arraignment. If he had, she might have been able to resolve part of the issue in his favor. I covered that hearing before, and Judge Bryant specifically told him there's a process for handling older cases like his. But instead of listening, he went straight into the usual sovereign citizen routine, asking for her recusal instead of letting her fix the problem.
Have a rebuttal.
Yes.
Okay, Judge, I would like to, if it's possible, I know you guys are on phone, so should have access to recordings of these hearings and things of that nature. I believe that prosecutors fabricated facts to you because I was not rude. All I asked her is, like, she said, what do you want to be done with the case? I said, I would like to challenge jurisdiction. Michigan and federal law requires once jurisdiction is challenged, it must be proven. How is it that the prosecutor knows statute of limitations? They're licensed. I'm not licensed. I've studied for years in prison. And they don't know that there's a statute of limitations. This has been good prosecution because of my complaints against Kim Worthy. And the record will reflect the evidence. And I object to her statements.
Court having had a chance to hear the arguments of the moving party as well as the arguments of the prosecutor. The moving party is asking for a recusal or to have Judge Bryant disqualified based on Michigan Canons 1 and 2, based on that she is biased, as well as is not allowing a person to be able to closely argue their case. The moving party is stating that he wants to challenge jurisdiction and that he was not allowed to do so. The prosecutor is stating that there was only a proceeding at an arraignment and that the prosecution hasn't even got to the point where they have established whether they want to move forward with the case, but that was not allowed to happen because in their view, there was disruption in the court and there was a breakdown. The moving party is disputing that. He's saying that I could go to the video or the tapes to dispute that.
Your Honor doesn't even need the tapes for this one. Judge Bryant didn't go completely off on him, maybe just halfway. But honestly, that's pretty mild for her considering what she was dealing with.
At this time, the court is not going to make a decision at this point. I am going to pull the tape, pull the transcript. I'm going to make a decision very quickly on this. I'm not going to let this continue. And even based on, the court does have an opinion probably on the likelihood of prosecution on a 21-year-old case. So we're going to come back on July 6th at 10 a.m. Please check your schedule, sir.
May I also, you say July 6th, sir?
Yeah.
Okay.
Yeah.
May I also, if I may,
check your schedule first. Check your schedule to see are you available for that time.
I'm available. I'm stuck here on tether, sir. I'm available at any time you guys want me to.
Okay. All right. So put it on your schedule for 10 o'clock on July 6th.
Okay, can I say one more thing? If you look at Crampton versus Michigan Department of State 395, Michigan 347 at 351, it says the United States Supreme Court disqualified judges and decision makers without a showing of actual bias in situations where experience teaches that the probability of actual bias on the part of the judge or decision maker is too high to be constitutionally tolerable. And I'm not saying like trying to attack Judge Bryant or whatever else, but she has an attitude like Judge Judy. She just cuts you off. And I'm just like, so when she kept doing it, this is when I objected and asked her to recuse herself.
And yes, it's true he had the right to speak, but that doesn't mean Judge Bryant is biased just because she didn't let him ramble on for an hour like Judge Sabri did. She simply runs a tighter courtroom, and he was acting like a stubborn child who couldn't handle that structure.
And sir, and again, as the chief judge, I don't have to have a showing of actual bias, but perceived bias, something in the fairness of justice. That is my stand.
All right, guys, that wraps up today's video. The next hearing took place the very next day with Judge McConico, but it wasn't recorded, so we don't know exactly what happened. What we do know is that the next time we see him, he will either be back in Judge Bryant's courtroom, reassigned to a different one if she's recused, or appearing again before Judge Sabri for his attempted murder trial. If you enjoyed the video, don't forget to hit that like button, and if you didn't, that's okay too. Leave a dislike. Either way, drop a comment below and subscribe with notifications turned on so you don't miss any of my future uploads. I'm Court is on the laws, and I'll see you next time in court.